Welcome back to Boom and Bust. I'm your host, Tony Clement, here with Malcolm Lavoie. He is an associate professor of law at the University of Alberta. Malcolm, as we continue to dissect the sort of your thoughts on the Canadian Constitution and what it means for economic and trade policy, you also mentioned local government autonomy. Maybe this principle of subsidiarity thrown in there as well. Can you explain to our viewers what you mean by that and what its import is?
Yeah, so at the time of Confederation, there were politicians, including John A. Macdonald, who wanted a more centralized confederation, including one that wouldn't be a federal state. But it was well understood at the time that there would be no agreement on confederation unless you had significant authority at the provincial level, and in particular, authority over property and civil rights, which at the time of Confederation was understood to encompass the full range of private relations among individuals, including economic relations. And part of the reason for that was the distinctive civil law tradition in Quebec. But it turned out to be quite fortuitous that the Constitution recognized that broad economic authority of the provinces. You know, Canada grew from being a country of four relatively small provinces on the sort of eastern part of North America to a transcontinental federation. And effective economic governance in a large and diverse country like Canada requires significant decentralization so that you can have decisions made on the basis of local ideas, values, circumstances, et cetera. And so, I argue the Constitution reflects essentially a presumption of economic authority at the provincial level, unless there's a good justification for centralization. And you see that on some of the issues related to interprovincial economic relations, on issues like the infrastructure of exchange, currency, and banking. But for the most part, the presumption is in favor of local decision-making authority.
Obviously, you have the root, which is the Constitution Act. What has the jurisprudence taught us, if anything, since that act was passed?
Yeah, great question. So I would argue that in the early days of after Confederation, courts were fairly faithful to the vision of the Constitution. And part of that was a faithfulness to the exclusivity of federal and provincial powers. So the Constitution is clear to the point of redundancy in saying that provincial heads of power are exclusive to the provinces and federal heads of power are similarly exclusive. And that serves a purpose, right? So that protects provincial autonomy on the one hand. And on the other hand, the exclusive nature of federal authority over, say, interprovincial trade, interprovincial transportation, that preserves the ability of Parliament to ensure that there's an integrated national economy and that you're not having, say, protectionist decisions made in relation to some of those matters. And so, I would argue that courts for many decades after Confederation were quite faithful to the vision in the Constitution. It's only in recent decades that there's been a kind of drift away from it. And part of that drift has been in a move to a more flexible conception of federalism, where you allow federal and provincial heads of power to overlap significantly. You allow a federal measure to significantly impact matters under provincial jurisdiction. You allow provincial measures to significantly impact, say, federal measures like interprovincial trade, that kind of thing. And that undermines the economic vision from two directions. It has the potential to undermine local autonomy. At the same time, it also gives provinces quite a bit of leeway to impose barriers to trade through provincially enacted measures.
Yeah, that's obviously been one of the issues that has bubbled up to the surface, the internal trade within Canada. So your assertion then is that there is direction to remove those barriers to trade then. That's what you see in the Constitution.
Yeah. And there's a few different sort of ways to approach this. One is, the division of powers, which I've mentioned, that, it matters that the Constitution implicitly says provinces cannot legislate in relation to interprovincial trade, cannot legislate in relation to interprovincial transportation and communication. That prevents provinces from erecting certain kinds of trade barriers. There are also more direct measures in the Constitution, including Section 121 of the Constitution Act 1867, which says essentially all goods are to be admitted free from one province to the next. So it's a rare instance where you see the Constitution really directly saying this is a policy priority, and there shouldn't be any barriers to trade between the provinces. As I mentioned in the book, that provision, Section 121, was given a fairly narrow interpretation by the Supreme Court of Canada in a decision called R.V. Como.
We're going to take a brief break there, Malcolm. Hold that thought.